it's Luke with Bizhaven. Today, we're going to talk a little bit about PAGA, the California Private Attorney General's Act, and the recent reform which has come into effect since July 1st, 2024. On that date, Governor Newsom signed into law AB 2288, which legislators believed they needed this reform simply because there was a lot of deficiencies within PAGA cases. So we're going to dive into some of that reform today. As mentioned previously, this bill will aim to rectify some of those deficiencies within PAGA lawsuits. One of the major sticking points is the surge in the gotcha lawsuit. And a lot of these lawsuits are over minor and technical labor code violations and the limited advantages that employees have. While PAGA lawsuits will continue to pose a risk for California employers, the recent emergency legislation, it offers practical strategies to mitigate exposure and to minimize penalties if you take some simple steps. So before we dive into some of the specific details of this reform, let's take a holistic view and kind of break it down into layman's terms. So now, if you make a mistake, rather than getting grounded for a month, you're getting a chance to have a stern talking to and take some corrective action, right? Those employers that do take that corrective action, act swiftly, fix their policies after receiving that PAGA notice, and they make those workers whole, they're going to get capped penalties. On the opposite end of the spectrum, if you're going to play more like Mr. Burns from The Simpsons, you're going to get higher penalties because you're out there with malicious intent, acting fraudulently, and encouraging or not discouraging those oppressive actions. So best thing to do if you get that notice is to begin that corrective process. Obviously, Bizhaven and our team can help do that. All right, let's dive into some of those key takeaways from this reform. Standing requirements. Previously, the named plaintiff in PAGA litigation, they could pursue penalties for any of the alleged labor code violations covered by PAGA, even if they haven't experienced it themselves. Now that named plaintiff, they'll have to personally experience those violations in order to pursue action on that. And that aligns the PAGA principles with class action principles. Some of the other ones are default penalty, the $100 default penalty per aggrieved employee. That still remains the same on the initial violation, but that $200 penalty has been replaced. The other thing is there's going to be no derivative penalties. So an employee recovering a penalty for a wage violation, they cannot collect additional penalties for the same underlying conduct. Continuing down the list of reform, those caps on penalties, which we kind of hit on earlier, employers who take all reasonable steps to prospectively be in compliance after PAGA notification, they're going to benefit from those capped penalties. Isolated errors occurring within 30 days or 4 consecutive pay periods, they're going to have a maximum penalty of $50. Wage statement violations are now capped at $25 if the required information is discernible from that statement. Injunctive relief is another reform. Employers who cure all alleged violations and take all reasonable steps to be prospectively in compliance within 60 days of receiving that notice, they're not going to be liable for penalty. Which is a good thing. And then employer options. Larger employers, they have the option or they can choose to pause litigation while pursuing court-supervised settlements for those penalty claims. Smaller employees have the option to seek assistance from the labor commissioner in resolving claims before formal litigation begins. These reforms aim to balance employees' rights while ensuring that PAGA remains an effective tool for enforcing labor laws. So the question remains, what should we do now? Like to say, an ounce of prevention is worth a pound of curing. Start taking those reasonable steps, those corrective actions to comply with the labor code before you get a request for records or get a PAGA notification. What are some of those reasonable steps? Maybe it's a payroll audit, and then whatever you found in that audit, you're implementing that into your organization. Maybe it's making sure that all your written policies and programs are up to date, or training up your supervisor, your managers on current labor code or wage and hour compliance. All of those different things can help you if you do get stuck in a situation. Obviously, there's going to be more information to come out as the year progresses. But hopefully this video was informative and helped you understand a little bit about what that reform was about. If you need anything, reach out to us here at Bizhaven. We're happy to support your organization in any way possible. Thanks.